Morning. I'm Rita McCannon. I'm a lawyer in Huntsville, Alabama. I'm so glad to be with you today.
Morning, New York. My name is Thomas Mackey, and I'm with the University of Louisville History Department and the Brandeis School of Law at U of L.
I'm Hank Chambers, down here at the University of Richmond School of Law. I teach a little criminal law, white-collar crime, voting rights. So there we have it.
Please tell us who you are.
Good morning. My name is Brendan Katz.
Good morning. My name is STANLEY Moukhametzianov.
Good morning. My name is Stephen Moukhametzianov.
And our three amazing coaches here today are Miss Rutter,
Good morning,
Azoff, and Miss Kovad. And along with that, we have our principal, Miss Cohen, here with us as well.
Wonderful. Welcome. Welcome. All right. I have to ask, two of you have a very uncommon name. Are you brothers, cousins?
Yeah, we're twin brothers.
Wow. Wow. Say your last name for me again, and then I'll quit wasting time.
It's Moukhametzianov.
You'll pardon me if we just say Stephen and Stanley.
Yeah, it's all right.
All right. We are on Unit 3, Question 3. And if you all are up for it, I'll read it, okay? And thank you all for joining us this morning, by the way. In 2020, we celebrate the ratification of the 19th Amendment, which recognized the right of women to vote. Despite recent controversy, the Equal Rights Amendment has not yet been declared ratified. What are the similarities and differences between these two amendments? What impact, if any, has the 19th Amendment had on women in achieving equality with men in the United States and around the world? What are the advantages and disadvantages of states passing their own equal rights amendments rather than ratifying a national constitutional amendment? And you may begin.
Supreme Court Justice Ruth Bader Ginsburg once said, "I would like my granddaughters, when they pick up the Constitution, to see that notion, that men and women are persons of equal stature. I'd like them to see that it is a basic principle of our society." 3 years after the ratification of the 19th Amendment in 1920, the Equal Rights Amendment was proposed shortly after as a means to provide legal equality and prohibit discrimination on the basis of sex. However, in the 1970s, the Equal Rights Amendment was not passed and therefore did not become a law. While the 19th Amendment and the Equal Rights Amendment are similar in their core belief of expanding and protecting rights on the basis of sex, they differ vastly in their approach and what they hope to accomplish. The purpose of the 19th Amendment was very narrow and focused solely on granting women the right to vote. However, voting was not and still is not the only form of discrimination women faced, and the Equal Rights Amendment was attempting to remedy this limitation. The Equal Rights Amendment was far more vague by granting complete equality under the law despite a person's gender. Many women feared that such an amendment ignores basic biological differences between sexes and would force women to be far more economically independent and potentially be drafted into the military. As such, the Equal Rights Amendment did not reach the required number of 3/4 of the states and was not ratified. Many people, both men and women, felt that other remedies could resolve this issue without the need for an amendment to be passed.
Although not entirely ending discrimination on the basis of sex, the 19th Amendment remains a revolutionary milestone by acting as a catalyst to further expand and redefine the rights of women. It would be this amendment that established the foundations for protections such as the Equal Pay Act of 1963, which provided men and women with equal pay for equal work, and Title VII of the Civil Rights Act of 1964, which prohibits employers from discriminating against employees on the basis of sex, race, national origin, or religion. Furthermore, through this movement, Title IX of the Education Amendments Act of 1972 was passed and effectively reduced gender discrimination in schools. In the Supreme Court case of Craig v. Bourne, the decision greatly improved equality between men and women when they ruled that a gender discriminatory drinking age law was unconstitutional. In modern views, the 19th Amendment would further influence gender equality through legislation such as the Lilly Ledbetter Act of 2009, which further ensured worker protections against pay discrimination. Additionally, through activism such as the Me Too movement and pro-choice movement, the initiative that began with the 19th Amendment strives to further end gender-based discrimination and expand the rights of women. From a global perspective, the 19th Amendment would influence the passing of similar voting rights amendments in nations such as France and Britain, and spark feminism movements throughout Europe, such as the Women's Liberation Movement, which improved working conditions for women and gave them equal pay. One benefit of having states pass their own Equal Rights Amendment is that it would prohibit the federal government from further expanding their power over civil liberties. However, this same ideology also encourages disunity throughout the nation that could spark conflict and further divide the people. With Virginia being the most recent state to pass their own Equal Rights Amendment, the number of states that have passed their own Equal Rights Amendment is approaching the number needed to pass a national amendment. As such, in an attempt to unify the nation and reinforce equality between genders, the passing of a national Equal Rights Amendment would be an effective solution. Susan B. Anthony once said, "Women must not depend upon the protection of men, but must be taught to protect herself. Men their rights and nothing more, women their rights and nothing less." Thank you.
Thank you. Let me ask you, since we women have the right to vote, why have we not elected a woman president?
Well, exactly. That's one of the major concerns within this nation is that for so long we have not had a female president. And what this has inspired is that even in this election, candidates like Joe Biden are voluntarily going out of their way and saying that their running mate would be a woman for vice president, simply because we have never had a female president or vice president in the history of this nation.
And to add on to what my colleague has said, I think we can see that the societal norms are changing around the country. As if we look at how many senators are in the Senate today, 25% of the senators are female. So we can see that a push is being strived for women to be more involved in the government as well.
So you say 25% of our senators are women?
Yes, 25% of women are in the Senate. 25% of the Senate is women.
Okay. Okay. In terms of the 19th Amendment, did the 19th Amendment bring about the Civil Rights Act of '64? Is that what I heard you say? Or is it that the 19th Amendment just created an atmosphere in which the Civil Rights Act of '64 could be passed?
We believe that the 19th Amendment sort of established the foundations, where on top of that, in regards to like movements as well, established this ideology that women should be able to get more rights and should be equal to men, which sort of led to the Civil Rights Act being passed.
Okay. Did the 14th Amendment have anything to do with general equality and treating women well, or did we have to wait for the 19th Amendment for women to be treated relatively well under the Constitution?
Well, one aspect to consider with this is the Supreme Court case of Minor v. Happersett, in which the Supreme Court ruled that the suffrage was not a right of citizenship and that the 14th Amendment did not guarantee women the right to vote. And so what this shows is that the Supreme Court has not always been progressive in their activist nature, but rather they have focused more over on the constitutionality of an issue.
You know, let me follow up on Professor Chambers. Look, the 14th Amendment's got an equal protection clause in it. And the 14th Amendment is clearly the second American Constitution. And part of what I'm trying to understand is this relationship between the 19th Amendment, the proposed ERA, and the equal protection clause of the 14th Amendment. Can you, if we've got the equal protection clause, what's the need then for the 19th Amendment or more recently the Equal Rights Amendment? Help me understand that relationship.
Well, one of the greatest,
trying...
you can go.
Please, please. No, please.
One of the greatest need for an Equal Rights Amendment is that even though we have the 14th Amendment and we have the 19th Amendment, there's still a very large pay gap in which women are making 78 cents on the dollar, even though these amendments are in place. And it shows that there is still we have improved, but there's still a greater need for more progression and activism for equality.
But isn't that a cultural issue rather than a constitutional or legal issue?
Well, if we say that that equality should be natured in the country, then all men and women should face similar pay differences. We can look at the issue of the Olympic sports teams of women. The women won the gold cup, but they still were underpaid. And when the men won, they got more pay. So if we look at the whole idea of equality, men and women should be able to pay, not just as a cultural issue, but as a societal issue and as a constitutional issue, as you stated.
And you think the Equal Rights Amendment will assist in that, help in that, hinder that?
Well, yes, we believe the Equal Rights Amendment would definitely be able to help in this regard. And it goes as far as to say that the quote we began with by Ruth Bader Ginsburg, in which she stated that even it would establish the basic principle in the society that men and women have equal stature. And what this would do is that it would change the mindset of society, and it would show that the public, that men and women are to be equal in this nation. And that is not something that is discussable or controversial.
Why has it taken us so long to not get very far?
Well, one of the major concerns is that some of the states viewed the ERA as a federal power grab, where instead of the states being able to incorporate equal rights in their own constitutions, the federal government would now gain authority over it and be able to regulate the rights between men and women.
And we can see this, my apologies, please.
No, go ahead.
And we can see this issue, especially today during this pandemic, as a woman's right to abortions are being limited, because we can see Texas, for example, are closing their abortion clinics and not allowing women to have an abortion. So the states are making this as their reserved power and not as a federal power that the whole Constitution can really remedy this issue.
Bless your heart for not blaming it on Alabama again. And you know we've done that too.
And to further add on to what my colleague has said, if we look at the case of United States v. Lopez, what happened in that case is there's an opportunity for the federal government to unjustly expand their power through the Commerce Clause, and they tried to establish gun-free zones through the Commerce Clause, and the Supreme Court said that this was unconstitutional. And we would see that the same would occur if an Equal Rights Amendment would be proposed because of how general and how vague it is. And so what this establishes is that many people oppose the Equal Rights Amendment because of this notion and this fear.
All right, thanks. Good job. Thank y'all.
Thank you.
All right.
Very much.
Judges, would you like to follow up?
Sure. This was, you guys did a solid job with a tough topic. Tough in part because we've had the 19th Amendment for so long, and we still have a lot of issues and a lot of places where we need to go. And the structure of the Constitution doesn't necessarily help us all that much. Y'all mentioned a lot of statutes and a lot of cases, and interestingly enough, a lot of those cases don't really come from the 19th Amendment, they come from the Commerce Clause. All right, so we've used the Commerce Clause in order to do some of the things that the 14th Amendment should have done, maybe the 15th should have done, and the 19th should have done. So it's a hard issue, but you all attacked it pretty well and have thought your way through a lot of these issues. So I commend y'all for that.
Thank you.
Thank you.
Yeah, I want to pile on. My question really drove you to trying to understand one of the historians' issues is what drives cultural or social change, law or social change, and that what we end up with is this complex mix of constitutional principle, legal rules, and social behavior. And question on its surface doesn't look that messy, but once you start pushing into these issues, it turns out to be pretty messy indeed. And I thought you guys did a really nice job of sort of unpacking some of the issues and laying out the major ideas and values. So I thought it was a very nice job. Well done, guys.
Thank you.
Thank you very much.
I agree. Thank y'all so much. Really good. And thank you for taking the time during one of the most difficult times any of us have ever experienced to prepare, to learn, to continue to devote the time when you really didn't have to. It was wonderful. Thank you.
It was our absolute pleasure. Thank you so much for listening to us and for having us present in front of you.